Good afternoon. My name is Alexander Bernier, and today I'm going to be talking to you about data protection and data privacy within the context of the COVID-19 pandemic. More specifically, I'm going to be discussing data protection and privacy law, as well as research ethics as they apply to international data sharing and data mining within the context of an international pandemic response. Before I dive into the heart of the topic, I'd like to take a brief moment to introduce myself. I'm a research assistant at the Center of Genomics and Policy at McGill University's Faculty of Medicine. My background is in law, and I have generally focused my work on data privacy, data protection, and health data sharing, especially in genetic and genomic research. The argument that I'm going to make today is fairly simple and has two main prongs. First of all, I'm going to argue that data protection and data privacy laws create an enormously complex landscape for researchers that are intending to share data across international borders and across sectoral boundaries. The second argument that I'm going to make is that data mining and big data methodologies present certain group privacy risks that aren't accounted for in the general framing of data protection and data privacy laws. What we can infer from this is that data protection and data privacy regimes can simultaneously be stifling for certain research activities that could otherwise be easily performed internationally. The second thing we can infer is that some privacy risks and some risks of stigmatization or discrimination are left out of the scope of data protection and data privacy. I will now discuss certain ethical legal barriers to widespread health data sharing that can emerge in data protection and privacy laws. Before I dive into this topic, it's beneficial to consider what the benefits of international health data sharing are. First of all, performing international health data sharing and more generally reusing existing health data can avoid the need to perform primary data collection from patients and from research participants. Participating in health research and performing health research can impose significant costs in terms of effort and resources on research participants and research institutions. In reusing data, some of these costs can be mitigated, and individual effort in research participation can be reduced, while also increasing the benefits that are gleaned from performing health research. International health data sharing can also be beneficial in assembling statistically significant research cohorts for health research where it would otherwise be difficult to do so on a purely local basis. For instance, the example of rare disease patients is a quintessential example of this difficulty. In bringing together data sets from rare disease patients across multiple nations and multiple research nodes, we can overcome the difficulty that is usually faced in assembling research cohorts among rare disease populations. Without bringing together this data, it could be difficult to conduct statistically significant research within the rare disease community. A third benefit of international health data sharing is that it becomes significantly easier to create the large data sets that are required to apply machine learning techniques or big data methodologies. Moreover, the variety and volume of data that is required to perform these techniques with maximum benefit is a lot more achievable if data sharing is being shared across international bounds. Fourth and fifth benefits of international health data sharing are that it becomes possible to replicate and validate prior studies reusing the same data all over again. If a an original study's data is not made available to further researchers and not made available to researchers in other institutions, it becomes very difficult to verify the authenticity and replicability of a particular study. Performing longitudinal or comparative research across different territories or across vast lengths of time generally necessitates the reuse of existing data sets and their combination with novel data sets that are coming from different locations or that are collected in the same location far later in time. Having assessed the benefits of data sharing and data reuse, I'm going to discuss the general structure of ethical and legal obligations incumbent on parties that are using health data. Generally speaking, there are different levels of rules that can apply to health data use. These can include national or supranational data protection and privacy laws, as well as the local or regional implementations of larger privacy laws that apply across an entire nation. A great example of this is the European Union's General Data Protection Regulation. The General Data Protection Regulation applies across all of Europe, but it has been implemented and modified in different ways across the different member states of the European Union. Other types of data privacy laws include local and sectoral laws that govern the health sector, the private sector, or the public sector. Within one country, it's very common to have one data privacy laws that governs private sector entities and a different data privacy law that governs private sector entities. Sometimes there will also be a third tier of data privacy laws that govern health sector entities. Other rules that can apply include research ethics rules that govern the use of federally funded research. For instance, in Canada, the Tri-Council Policy Statement is a singular document that all researchers using federal funds must comply with in performing research. Beyond all of these, there can also be local, institutional, or regional policies that govern health data use in clinical or research settings. Here are a few examples of privacy laws and ethics policies around the world, ranging from the supranational to the sector-specific to research funding policies. So we can see that one of the main reasons that it's very difficult for researchers that are collaborating and sharing data internationally to know exactly what ethical legal rules are applicable to them stems from the fact that ethical legal privacy rules are specific to a particular nation or sector, but that research collaborations don't necessarily bound themselves clearly to sector-specific or country-specific lines. If for instance, a private corporation is collaborating with a public institution across multiple national borders, it becomes very difficult to know exactly what combination of privacy laws and privacy rules will apply to that joint research effort. Now that we know that it's really difficult for researchers to clearly pinpoint specifically which research ethics instrument or data protection and privacy laws will be applicable to them at a given time, let's briefly look at some of the common elements of data protection law that usually apply across the board. Firstly, there's a general obligation to specify a purpose for which data is being used and to restrict one's uses of data to that purpose. Second, it is often not permitted to transfer data to third parties unless there's a lawful reason for doing so. There are also many limitations on transferring and sharing data outside of a particular nation or a particular territory. Furthermore, collection of data should generally be limited to the specific purposes for which the data is being collected and used, and to the minimum necessary data to accomplish those purposes. Once that purpose is complete, the data should generally be destroyed or made anonymous. Furthermore, individuals usually have formal rights to receive copies of their data, to withdraw their data or to request the destruction thereof, and also to ask that any errors present in the data be corrected. The framing of data protection rules can create potential difficulties for health research. First of all, in limiting the purposes of data use to the original purpose of collection, it can become difficult for health researchers to reuse liberally the data created in everyday clinical care activities or in quality assurance activities for future research purposes, in spite of the fact that such data sets would be very propitious to such secondary uses. Second of all, the requirement to limit data reuse to the minimum necessary for the anticipated purpose can create difficulties in assessing how much data can be used to perform big data analysis and machine learning methodologies, especially because such methodologies generally become more and more accurate and more efficient the more data is made available to them. Third of all, data destruction requirements and territorial restrictions on sharing or transmission or even storage can make it very difficult for participants in health research to ensure that communities that do not traditionally generate their own data can meaningfully participate in and benefit from data-driven research. Lastly, certain emergent technologies, such as machine learning and blockchain, could be fundamentally difficult to reconcile with data destruction and purpose limitation requirements, precisely because, in the case of the blockchain, it can be very difficult to destroy data that is already integrated in the blockchain, and in the case of machine learning technologies, it can be very difficult to specify a purpose of data use prior to the research and meaningfully limit the activities of, for instance, an unstructured machine learning algorithm to one predetermined purpose. The first key takeaway from the previous discussion is that the ethical legal rules applicable to health institutions can vary immensely across borders and across sectoral boundaries. This can mean that it can be very difficult to create a one-size-fits-all policy for sharing and using health data among institutions that operate in different economic sectors or across international boundaries. However, the COVID-19 pandemic response has required the fast and efficient and holistic reuse of data across commercial, public sector, health sector boundaries, and also across the entire world. The second trend that emerges is that certain tenets, key tenets, of data protection law are fundamentally difficult to reconcile with the anticipated use of health data within the health sector. Managing these difficulties is a shared responsibility among public health authorities and health sector actors. Health sector actors can best meet their ethical legal responsibilities by ensuring that data flows exiting an institution and reaching a different institution comply with the local ethical legal requirements incumbent on the releasing institution, and leaving the receiving institution to also ensure that their own obligations are best discharged. This can be done by ensuring transparent communication across institutions of ethical legal obligations and ethical expectations, and in carefully involving multidisciplinary actors from scientific, ethical, legal, and institution management backgrounds in decision-making across the board. Public health authorities, for their part, should establish clear guidelines showing their expectations and anticipations regarding the use of health data and the sharing of health data within the pandemic context. Special institutions, such as data trusts, could be created in order to ensure that data can be stored and warehoused for long-term use by health sector actors, rather than leaving these actors to ensure the compliance of their data sharing activities with ethics and law all on their own. In the long term, it may be necessary to reframe data protection in order to better allow individual rights to be reconciled with international broad reuse of data. Two analytical frameworks that can be used to do this are the framing of substantive rights and data protection by design. Substantive rights could be used instead of procedural, formal requirements to ensure that all individuals' data is protected without risking the incompatibility of formal obligations in different nations and different sectors from prohibiting the international sharing and reuse of data. Data protection by design is a framework already implemented in some nations which allows and in fact requires data protection to be incorporated into technological design and institutional structuring. This framework could allow for technology-neutral protection of individual privacy. I will now discuss certain potential privacy harms that are not accounted for by existing data protection laws. I turn now to privacy harms that are not accounted for in present-day data protection regimes. Privacy protection is generally limited to data that is identifiable and personal in nature. That is, it relates to a specific individual, and that individual could potentially have their identity or something related to their identity revealed by that data. Identifiability metrics differ from nation to nation and from law to law, but at their most broad, identifiability metrics refer to those that refer to data that relates to a person in its content, in the purpose of its use, or in the effect that its use has on an individual. The difficulty in using individual identity to frame data protection law is that some privacy harms can occur absent individual identification. For instance, if it becomes revealed that the members composing a particular database are predominantly members of a prison population, then those individuals could suffer stigma even without their particular identity being revealed. Furthermore, algorithms could profile a dataset and draw harmful inferences about individuals without any particular individual coming to know the identity of the underlying individuals composing that database. Lastly, data mining techniques could be used to ascribe sensitive inferences to groups or communities and to further marginalize or stigmatize them. Having acknowledged that privacy harms that affect groups rather than identifiable individuals can emerge, the question arises, how can we protect these individuals against group privacy harms? Two general methodologies emerge. The first is to alter the underlying data sets in order to ensure that sensitive inferences can't be drawn about the groups that compose them. The second is to use technological methods to allow free queries to be made of a larger data set, but prevent the database from releasing information that could lead to inferential or group-directed privacy harms. Beyond these methodologies, there is a retrospective possibility of looking at the way in which, for instance, a machine learning algorithm was trained or a statistical inference was drawn in order to determine if the pattern revealed is in itself biased or discriminatory. We can think of these as prospective and retrospective approaches. In performing COVID-19 data mining, Researchers should be mindful not only of their formal ethical and legal obligations, but also of the potential for bias or group discrimination to occur as a result of their data mining and data analysis activities. Moreover, researchers should acknowledge and disclaim any potential bias or limitation in the algorithmic tools or in the products of statistical analyses performed, especially if these will inform the decisions of public health sector authorities or the allocation of resources within the health sector. Lastly, data contributors should consider if the aggregate and de-identified data that they are making available to the public or integrating to health data repositories could be used to generate harmful inferences about the individuals or groups that compose these data sets. Thank you for listening to my presentation. I hope you found it informative and useful.